Docket number 4-CR-3371 had already been used. The case it belonged to was tried and closed in 1991. I was listed as defense counsel. I didn't pass the bar until 96. I need to say that again because I've been turning it over for 22 years and it still doesn't sit right. A complete case file, arraignment, motions, trial transcript, verdict, bearing my name, my bar number, and my handwriting from a trial that happened 5 years before I was licensed to practice law. Every page, every filing, every margin note. I'm getting ahead of myself. That's what the recorder is for. Start from the assignment. It was a Tuesday in October 2004. Shelby County Criminal Court was still running dual systems that year. Paper jackets in the clerk's vault, electronic entries in the early judice platform. Most of the older attorneys preferred the paper. I was one of them. I kept a leather-bound journal where I logged every docket number I'd ever been assigned, going back to my first case in 96. I started that habit in 99 after a clerk reused a number on me, and I spent 3 weeks untangling a double jeopardy problem that never should have existed. After that, I wrote every number down, every one. The Garner case came in through the usual channel. State v. Darius Garner, possession with intent to distribute, Schedule 2. 47 grams of cocaine found in the defendant's vehicle during a traffic stop on Poplar Avenue. Arresting officer was a Darnell Vick Jr., badge number 4471B. Straightforward. The kind of case I could handle with my eyes half shut, which by October of a year like that one, they mostly were. I sent my paralegal, Ruth, to pull the physical jacket from the clerk's vault. She'd been with me 11 years. She knew the vault better than most of the clerks did. I expected her back in 10 minutes with a thin folder, maybe an arrest report, a booking sheet, the charging document, 3 days' worth of paper at most. She came back in 20 minutes carrying a jacket that was 3 inches thick. I looked at it, looked at her. She set it on my desk without a word and went back to her station. Ruth wasn't the type to editorialize, but I could see it on her face. Something was off, and she didn't want to be the one to name it. I opened the jacket. On top was the Garner material, the arrest report, the booking sheet, the information sheet from the DA's office. Normal, thin, 3 days' worth of paper. Underneath it was a second case file. State v. Marcus James Lassiter, docket number 91-CR-3371. Division 9, my division, filed and disposed, 1991. The jacket tab was typed on an old Brother label maker, the adhesive yellowed and cracking at the edges. The paper had that specific smell, toner and dust, and something faintly chemical, like the glue they used to bind carbon copies in the early 90s. I pulled the Lassiter file out and spread it on my desk. Arraignment transcript, discovery packet, 14 pretrial motions, a full trial transcript, 287 pages, a verdict form, exhibits A through F, a sentencing recommendation. The whole architecture of a felony case, from first appearance to final judgment, filed in perfect procedural order. Defense counsel, listed on every document, my name, bar number, printed below my name on every filing, TNBPR 019847. Office address on the pleadings, 4 South Front Street, Suite 3, Memphis, Tennessee. In 1991, 412 South Front Street was a sandwich shop called Manny's. I ate there twice during my first year visiting Memphis before law school. My office didn't move to that address until 2001, when Manny retired and the landlord converted the space. My first thought was clerical error. Docket numbers get recycled. Shelby County's numbering system in the 90s was a mess. They ran through sequences too fast some years and had to patch gaps. Someone reused 3371 and the physical files got merged. It happens. It shouldn't, but it does. But then I started reading the motions. The third motion in the stack was a motion in limine to exclude chain of custody testimony on the drug evidence. I file that motion in every drug case, every single one. It's my standard template. I wrote the first version in '98 after a seminar on Fourth Amendment exclusionary practice, and I've filed variations of it ever since. The language in the 1991 motion was mine, not similar to mine. Mine. The same citation to State v. Harbison that I always lead with. The same parenthetical about field test kit contamination rates. The same structural tick where I split the argument into 3 numbered sections instead of using Roman numerals, because I think Roman numerals make briefs look pretentious, and I've thought that since law school. And the typo. 4th paragraph, 2nd line. The below described evidence. Hyphenated. It's wrong. Below described doesn't take a hyphen. I've been making that mistake for my entire career. My secretary corrects it half the time. The other half, it goes through. In the 1991 motion, it went through. Same paragraph, same line. I turned to the trial transcript, page 1, line 1. The case caption, the date, April 14, 1991. The judge's name, Helen Worthy. I knew Helen. She'd retired in '98. Good judge. Fair. Division 9. I started reading the cross-examination. My cross-examination, and my hands went cold. The technique was mine. Ask about the field test kit calibration first. Let the officer commit to a number. Then pivot. Don't attack the number. Attack the time gap between the traffic stop and the search. How many minutes? Were you alone with the vehicle? Where was your backup? Then circle back to the confidential informant's reliability. I developed that sequence in 1999 after losing a suppression hearing in the Taylor case. I lost because I attacked the test results directly instead of attacking the gap. I swore I'd never make that mistake again, and I built a new approach from scratch. By 2004, it was second nature. In 1991, I was a second-year law student at Vanderbilt. I hadn't taken evidence yet. I didn't know what a suppression hearing was. I had never seen the inside of a criminal courtroom. The margin notes were the worst part. I write in the margins of every transcript I review. It's a habit, like the journal. Small notations in a kind of personal shorthand I developed over the years. I never taught it to anyone. It's not a system, really. Just abbreviations and arrows and circled words that mean something to me and nothing to anyone else. The 1991 transcript had my margin notes on 43 pages. My handwriting, my shorthand. Notes about witness credibility, about evidentiary gaps, about things I wanted to follow up on. Written in ink that had faded the way ink fades over 13 years. I called the clerk's office, asked about 91R 3371. The clerk, a woman named Denise whom I'd known for a decade, searched the judici system. Nothing. No case. No defendant named Lassiter. The numbering sequence jumped from 91 CR 3370 State v. Humphrey disposed to 91 CR 3372 State v. Dalton disposed. No 3371, not reassigned, not sealed, not expunged. It had never existed. But the file was on my desk. 287 pages of trial transcript. 14 motions in my voice. My bar number on every page. A bar number that wasn't issued until 5 years after these documents were supposedly filed. I sat there for a while. The fluorescent light above my desk had been flickering for a week. The ballast was going, and I kept forgetting to call maintenance. It made a sound like a wasp trapped in a jar. I listened to it and looked at the 1991 file and tried to think of a rational explanation. Then I opened my leather journal, flipped to the front end paper, where I'd written my first entry in 1999. First logged, Case 96-012, State v. Williams. My first case. The one that started it all. Below it, in my handwriting, unmistakably my handwriting, in ink that was older, darker, slightly more faded than the 99 entry above it, 91 CR 3371, State v. Lassiter. I didn't write it. I know I didn't write it. I started this journal in 1999. I have never made an entry for a case from 1991 because I didn't have cases in 1991. But there it was, in ink that had aged like it had been sitting on that page for longer than anything else in the book. And the handwriting was mine. I should have taken the file to the presiding judge. Should have filed a report with the clerk. Should have done any of the things a reasonable attorney does when evidence appears that doesn't make sense. Instead, I did what I've done for 26 years when a case doesn't add up. I pulled the thread. I cleared my desk and laid both files side by side. The 2004 Garner case on the left, the 1991 Lassiter case on the right, and I started comparing. Same charges. Possession with intent to distribute, Schedule 2 controlled substance. Same quantity, 47 grams, not approximately, not roughly, 47. Same form of the drug, powder cocaine, off-white, field-tested positive with an IK reagent kit. Same location of seizure, the defendant's vehicle, driver's side door panel. Same basis for the stop, broken taillight westbound. The arresting officer in 1991 was listed as Darnell Vick, badge number 4471. The arresting officer in 2004 was Darnell Vick Jr., badge number 4471-B, father and son. I knew Vick Jr. He'd testified in 2 of my cases the previous year. Solid officer, by the book, no history of misconduct. I didn't know his father had been on the force, but the badge number convention was standard for MPD legacy hires. The department used to append a letter suffix when a direct relative joined under the same badge series. Same confidential informant code in both files, CI 2209. Same lab report format. Same chain of custody form, Form 12A, Shelby County Sheriff's Office Evidence Division, a form they hadn't updated since 1988. I sat with that for a while. 2 cases, 13 years apart, the same case. Played out with different names, different dates, and the same everything else. One of them had a defendant who existed, the other had a defendant who didn't. I checked thoroughly. Marcus James Lassiter. Date of birth per the 1991 file, March 14, 1967. I ran him through every database I had access to. No birth certificate in Shelby County, none in Tennessee, no social security number match. No driver's license, current, expired, or suspended. No arrest record in NCIC. No entry in the Tennessee Offender Management Information System, which should have had him if he'd been convicted and sentenced to 8 years as the verdict form indicated. No record of incarceration, no parole file, no probation officer assignment. Marcus James Lassiter, as far as every public record in the state of Tennessee was concerned, had never existed, had never been born, never been arrested, never been tried, never been convicted. The only evidence that he was real was a 3-inch case file in my office with my bar number on every page. I went to the courthouse basement. The archived records from the 90s were stored on metal shelving units in a room that smelled like pipe insulation and old carpet adhesive. The humidity was wrong, always too high, and the files had a damp, swollen quality that made them stick together when you pulled them from the shelf. I found the 91 CR section, walked the shelves until I reached the 3300 block. 91 CR 3368, 336090, State v. Humphrey, a simple assault disposed by plea in November 1991, jacket sealed with a rubber band. Then 3372, State v. Dalton, second-degree burglary, jury trial, convicted. The jackets were tight against each other on the shelf, but the gap between them was wrong. There was about 2 inches of empty space where a file should have been. And on the shelf lip, below the empty space, a typed label on a brother label strip, the plastic yellowed, the adhesive cracked, 3371, State v. Lassiter. The label had been there for years, possibly since 1991. The yellowing was uniform with the labels on either side of it. It wasn't placed recently, it had aged in place, so the file had been here, in this exact spot. Someone, or something, had moved it into the 2004 Garner jacket, where Ruth found it in the clerk's vault upstairs. And the system had no record it had ever existed, but the shelf still remembered. I stood in that basement for 10 minutes, looking at a 2-inch gap between two case files and a label for a man who was never born. The overhead pipes ticked with condensation. A fluorescent tube at the far end of the row buzzed at a frequency that set my back teeth on edge. I left. Back at my desk, I made a phone call I probably shouldn't have made. Judge Helen Worthy had retired from Division 9 in 1998. She lived in Germantown now, played bridge on Tuesdays, and still answered her phone like she was on the bench. Surname first, clipped, no pleasantries. I told her I was looking into an old case that might have been heard in her division. 91 CR 3371, State v. Lassiter. Drug possession with intent. She was quiet for a moment. Then she said she didn't recall it. I asked if she was sure. It would have been a trial, not a plea, 2 days in April 1991. She said she would remember. Division 9 was on the civil calendar that year. They weren't hearing criminal matters. She'd spent most of April 1991 on a complicated property dispute between two churches and a railroad easement. She didn't try a criminal case in Division 9 until she was reassigned to the criminal docket in January 1992. I asked if she'd check her personal docket journal. She kept one. All the old judges did. She put the phone down. I heard a drawer open, pages turning. She came back and said 91 CR 3371 was not in her journal. Nothing between 91 CR 3340 and 91 CR 3395. I thanked her. She asked me why I was looking at a case from 1991. I told her I wasn't sure yet. She made a sound that might have been a laugh and told me to let her know if I figured it out. She sounded like she meant it. I hung up. I was running out of rational explanations. Clerical error doesn't produce 287 pages of trial transcript in my voice. A recycled docket number doesn't generate 14 motions using techniques I hadn't developed yet. A misfiled case jacket doesn't come with margin notes in my handwriting. But I hadn't gotten to the worst part yet. I'd been avoiding the verdict form. It was the last document in the 1991 file, sealed in a manila folder with a red verdict stamp on the tab. I'd glanced at it on the first day. Guilty, 8 years, 12 juror signatures. And set it aside because I was more interested in the transcript. Now I opened it properly. 12 signatures on the verdict form as required, all legible. I pulled the Shelby County jury pool records for 1991. They were available through the clerk's archive system, one of the few things that had been digitized. I ran the names. 11 of the 12 jurors appeared in the records. Real people, properly summoned from the 1991 pool. 3 had served on other juries that same month. 6 of the 11 were still alive. I could have called them. I didn't. I wasn't ready for what they might say. The 12th signature was different. Not in the system, not in the jury pool. I stared at it for a long time. The handwriting had a distinctive quality. The capital letters were sharp and angular, but the lowercase letters were soft, almost childlike. The G in the last name had a pronounced swoop, a decorative flourish that felt out of place on a legal document. I don't know why I did what I did next. Instinct, maybe. Or the part of my brain that had been a defense attorney long enough to know when a signature tells a story the signer didn't intend. I opened the 2004 Garner file, pulled the booking card from 3 days ago. Darius Garner's signature at the bottom, acknowledging his rights upon arrest. The same handwriting, not similar, not consistent with, the same. The same angular capitals, the same soft lowercase letters. But the G was different, no swoop, no flourish. Garner signed his name like an adult, clean and simple. The 12th juror on a 1991 verdict form, a trial that never happened for a defendant who never existed in a division that wasn't hearing criminal cases, had signed with the childhood handwriting of my 2004 client, a man who was 8 years old in 1991. I closed both files. I sat in my conference room, the one with the long table and the window that looks out on nothing, just the brick wall of the building next door. And I listened to the clock. It was one of those institutional wall clocks with a second hand that jumps instead of sweeps. Every tick was a small mechanical percussion. The radiator under the window clicked twice and went silent. The light through the Venetian blinds made bars across the table. I sat in the bars and tried to find the part of this that made sense. I didn't find it. I met with Garner the next morning. Standard pretrial conference. He was 21, quiet. The kind of client who sits with his hands flat on the table and answers questions in as few words as possible. Not hostile, just economical. I'd represented hundreds of men like him. I understood the posture. I didn't mention the 1991 file. I had no way to explain it, and I've learned, the hard way more than once, that introducing something you can't explain into a client relationship only makes the relationship worse. So I tested him, carefully. I asked if the name Marcus Lassiter meant anything to him. He thought about it, said no. I asked if he'd ever been to Division 9 before this case. He said this was his first time in criminal court, first time in the building. I believed him. His record was clean before the arrest, not even a traffic citation. Then I did something I still can't fully justify. I copied the 12th juror's signature onto a blank sheet of legal pad paper. Just the signature. No context. Slid it across the table and asked if he recognized the handwriting. Garner tilted his head. Looks like mine, but I didn't write that. That's how I used to sign stuff when I was a kid, he said. See the G? That swoopy thing? My mom made me stop, said it looked juvenile. I was 10, 11 maybe. He wasn't disturbed. Mildly curious, the way you'd be curious about an old photograph of yourself in clothes you don't remember wearing. Then he lost interest and asked about the trial timeline. Breath. I prepared for trial. Filed my motions. The motion in limine on chain of custody, my standard template. 3 numbered sections. I even caught myself writing the below described and corrected it. No hyphen. Proofread twice, had Ruth file it. The next morning I pulled up the filed version in Judici. The motion was there, filed, stamped, but the 4th paragraph, 2nd line, the below described evidence, hyphenated, the version I corrected, the version I specifically did not file. My hard drive copy still showed the correction. The clerk's system showed the 1991 typo. 2 of the 3 motions I'd filed had deviations between my drafts and the filed versions. Every deviation matched the 1991 file, not my 2004 drafts. The 1991 originals. The trial was set for November 4th and 5th. 2-day bench trial. I advised Garner to waive his right to a jury. I told him the judge assigned to Division 9, Judge Patricia Odom, who'd taken over after Worthy retired, was fair on drug cases and more likely to weigh the chain of custody issue seriously than 12 strangers would. That was true. It was also true that I couldn't sit in a courtroom and watch 12 people sign a verdict form. Not after what I'd seen. Garner agreed. He was easy about it, the way he was easy about everything. Like the outcome had already been decided and we were just walking through the steps. Day 1. Officer Vic Jr. took the stand. Direct examination, routine, competent, cross-examination, I stood up, opened my mouth, and the words that came out were from page 147 of the 1991 transcript. Officer Vick, can you describe the field test kit you used on the substance recovered from the defendant's vehicle? That was my question. But it was also, word for word, the first question in the 1991 cross-examination of Darnell Vick Sr. I tried to deviate, asked about the lighting conditions during the stop, a question not in the 1991 file. I said it clearly. The court reporter's real-time display showed my actual question. Lighting conditions. The next day's certified transcript, page 148, line 6. The calibration question. The question I didn't ask. The lighting question was gone. I checked with the court reporter, Janice. Her raw steno notes showed the calibration question. She said that's what I asked. The audio backup confirmed it. My voice asking about calibration. I heard myself say something I didn't say. Day 2. I stopped fighting the transcript. I asked the questions that came to me, and they were the questions from 1991, and the court reporter recorded them faithfully, and I let it happen because I didn't know how to make it stop. Verdict, not guilty. Insufficient chain of custody documentation. Garner shook my hand without smiling, left the courtroom like a man leaving a dentist's office. That night, back in my office, the building empty, the hallway fluorescents on their timer cycle, every other fixture off. I opened the verdict form. It had changed. The form that had read guilty, 8 years, Tennessee Department of Correction, now read not guilty. The line for jury signatures was blank because it was now a bench trial, no jury. At the bottom, in the space for the presiding judge's signature, Helen Worthy, Division 9. And the ruling language, the 3 paragraphs explaining the basis for acquittal, was word for word identical to what Judge Odom had said that afternoon. I went through the rest of the file. Every motion, every transcript entry, every ruling, rewritten to match the 2004 case. But the dates remained 1991. The defendant's name remained Lassiter, and my bar number still belonged to a man who was studying torts at Vanderbilt. I put the file back in its jacket, drove to the courthouse, used my after-hours key to access the clerk's vault. Walked to the 91 CR shelf, filed the jacket in the 2-inch gap between 3370 and 3372, where the yellowed label had been waiting for it. A week later, I checked the electronic docket system. Case 91 CR 3371, State v. Lassiter. Status, disposed. Defense counsel, my name. Last activity date, November 5th, 2004, the date of my trial. The case existed now. The system had caught up, or the system had always known and was done pretending otherwise. I filed a request with the Tennessee Board of Professional Responsibility for my complete filing history. I do this periodically. It's part of maintaining clean records for malpractice insurance. The board sent back a spreadsheet listing every case I'd ever been assigned. According to their database, I had been a licensed attorney since 1991. My bar certificate, framed on the wall behind my chair, says 1996. The board says 1991. 5 years of cases I don't remember. I called the board. The woman pulled my file, read my admission date, 1991. I told her my certificate says 1996. She said there was a data migration in 2001 and some records had entry errors. She offered to submit a correction. I told her not to bother. That was 22 years ago. I'm recording this on my last day. The boxes are mostly packed. Ruth retired 3 years ago. The office still smells the same. Toner and dust and old coffee and something faintly chemical that I've never been able to identify. I checked the board's online portal this morning, one last time. My profile lists 31 years of practice. My certificate still says 26. Somewhere in that 5-year gap, in docket numbers I can't find and courtrooms I don't remember, There are cases with my name on them. Cases I didn't try, clients I didn't represent, verdicts I didn't hear. I'm leaving them for whoever takes this office next. If you're listening to this and you're sitting at my desk, check the bottom drawer on the left side. That's where I kept the journal. The leather one with the docket numbers. The first entry, the one I wrote, says 96. The one below it, the one I didn't write, says 91. I've made my peace with the 26 years I remember. The 5 I don't. I'm leaving.